who do we have ready first?
We have several first, including Mr. Michael Salazar from Mr. Heath Hyde whenever he's available. Other than that, we have Mr. Joshua Key with Jeff Sanders.
All right, let's have Mr. Salazar step up to the podium.
Come on.
All right, Mr. Hyde, are you ready? You'll need to unmute your device.
How about now?
All right, excellent. We have you now. Mr. Salazar, can you see and hear your attorney, Mr. Heath Hyde?
Yes, sir.
And Mr. Hyde, can you see and hear Mr. Salazar?
I can, Your Honor.
All right, Mr. Salazar is set for hearing on his motion to revoke today. Is there any announcement from parties?
Your Honor, I visited with the district attorney this morning and got a copy of the motion, and we had talked about the case. We need to, I believe this case is going to reach an agreed resolution. We just need to reset it for me to be able to go and confer with him the offer that I got today. And I think if we would reset it, maybe one of your first times in January, that should resolve the case. Looks like I'm going to be there on, oh, you know what? I'm going to be there actually on December the 10th. I could reset it to the 10th if you have openings. I'm there in the afternoon of the 10th also to do a sentencing.
So next week, next Thursday?
Yeah, yeah.
Okay. That'd be fine. State any objection?
No, Your Honor.
All right, then the court will set Mr. Salazar for December 10th at 1:30 on his motion to revoke. Anything else, Mr. Hyde?
I think that's it, Judge.
All right, Mr. Salazar, we'll see you again in 1 week at the same time, okay?
Yes, sir.
All right, thank you, Mr. Hyde. We'll see you
Thank you.
next week.
Okay, thank you.
All right, Mr. Sanders, are you ready?
Yes, sir.
All right, Mr. Sanders. Is this Mr. Key?
Yes, Your Honor, it is.
All right, court call CR 25-3, State versus Joshua Daniel Key. I believe we're set for arraignment today. Is that correct, Mr. Sanders?
Yes, Your Honor, and I didn't know if we need to have some sort of finding by the court now that he's been returned from Terrell, a finding of competency first before proceeding with anything.
When was he returned from the hospital?
It would have been, they sent the letter October 29th, so I think he's been back here for November 13th.
Is this our first hearing since November 13th?
It is, Judge.
All right, and Mr. Sanders, are you or Mr. Key contesting the finding of competency by the doctor?
No, Your Honor.
What about the state?
We aren't either, Your Honor.
All right, I'm gonna take just a moment and all right, the court will find that the competency to stand trial evaluation was conducted by the Texas Health and Human Services Commission, Terrell State Hospital. That report was filed of record November 2nd, 2020. And the court finds that based on the report that the defendant, Joshua Key, has been found competent to stand trial pursuant to the report. And the court finds at this time that there is no objection to the report or its findings by Mr. Jeff Sanders, counsel for Mr. Key, or any objection by the attorneys for the state. And Mr. Sanders, you have had opportunity to review the competency evaluation report.
Yes, Your Honor, I have.
All right. And you have no objections. Do you have any other issues or concerns with the report?
No, Your Honor.
All right. State?
No, Your Honor.
Okay. All right. Then at this time, the court's going to find, based on the evaluation conducted, that the defendant has been restored to competency and will proceed, allow the state to proceed with its prosecution of Mr. Key for the second-degree felony offense of arson. All right, Mr. Sanders, go ahead.
Yes, Your Honor. Regarding the indictment, I know we were set for arraignment today. We've had a chance to review the indictment. Mr. Key's name is laid out correctly. We would waive the formalities of the arraignment, waive the reading of the indictment, and enter a plea of not guilty at this time.
Court accepts Mr. Key's plea of not guilty. We'll enter that into the record and we'll set Mr. Key for pre-trial. Are you available on January 26th, Mr. Sanders? I understand that this may have a little more discovery than a typical case. I want to give you a little bit more time to be able to review that unless you feel like sooner is better.
Judge, I think, I know I'm already scheduled from this morning, come back on January 7th, so I'd be fine if we set this for January 7th for pretrial.
You feel like that's going to give you enough time to review the discovery and file any contested pretrial motions?
I think it should, Judge, yes.
Okay. All right. Then the court will set Mr. Key then for pretrial on December 7th at 1:30 if Mr. Key is in jail, at 9 a.m. if he's on bail.
Okay. And Judge, prior to, I think right around the time that there was a finding of incompetency back in April, I had filed a motion or a writ for a PR bond because he hadn't been indicted at that point. And that was something that, talking with Mr. Key, he still wanted to have addressed. And so I was telling him I wasn't really sure if today would be the appropriate time to address it, but I wasn't sure if we might be able to have a hearing set maybe within the next week or a couple of weeks to deal with that.
And I'm just looking at my calendar for just a moment. The next available date I would have Mr. Sanders to take up that writ would be December 17th. That's 2 weeks.
Okay.
And the court wouldn't entertain that today since the state hasn't had notice of time to prepare for the hearing.
I understand, Judge. Then yeah, December 17th, that would work just fine.
Okay, and that, and you have filed, was that a writ or did you file that in the indicted cause?
It was before it was indicted, so actually I probably need to go back and refile it under this cause number. That's probably the best thing to do.
Okay. You'll do that and then just request that date of December 17th. I will mark my docket that we're going to have it that day, but when you file your motion, just ask for that day and I'll grant that. All right, anything else for Mr. Key?
No, Your Honor.
Okay, Your Honor.
Your Honor, this is Ms. Keisha Everett.
All right, court call CR 1889, State versus Keisha Marie Everett, and we're set today on the motion to revoke. Any announcement? Mr. Gilmore?
Judge, Mr. Gimble and I had a chance to speak this afternoon. We have an agreement worked out However, it's going to require the defendant to make some financial arrangements to meet her obligations she owes to the court and to the probation department. Upon doing that, we have an agreement for a plea. I think we're asking the court to reset this for next Tuesday. Is that correct?
Whatever next.
It's not going to take long to make those financial payments. So I think we can be ready for a plea next Tuesday.
That is our understanding, Judge.
And would that plea be for time or for probation?
It'd be for time, Your Honor.
It'd be for time. Would she be receiving time served and being released, or for additional time?
Additional time.
Okay. Then how about this? How about I set it on the 17th? Our next 3 dockets are pretty full. We're pushing 40 to 60 cases on the next 3. So if there's no problem with the parties, I can set it on December 17th.
No problem.
All right, Ms. Everett, we'll come back and we'll visit your case again on December 17th. And that'll be at 9 a.m. And
Yes, sir, Your Honor.
we'll have you brought over to the courthouse, or we'll appear via Zoom on that date. We'll let you know.
Yes, Your Honor.
All right, and Mr. Gimbel, I just want to address on the record for the state that James Matthew Thomason was set for arraignment today, and Mr. Gimbel and Mr. Thomason executed a waiver of arraignment, and that is set on January 5th at 1:30 p.m. All right, and is this Mr. Klump that's with you, Mr. Gimbel?
It is, Your Honor.
All right, court call CR 20-294, State versus Carl Gene Klump. Mr. Klump, I called your case at 9 a.m. and you were not present in the courtroom. Why not?
Yes, sir. I set my alarm last night for my phone, and it didn't go off this morning at all until my cousin woke me up and told me I had to be at court, and I got up and came up here as fast as I could. I was over at the jail before noon, like I was asked to be, and they said that y'all had went to lunch already, so I just waited around.
Well, I'm glad your bondsman, I believe they were watching the broadcast today and heard that your name was called and you weren't here. So had your bondsman not been watching and contacted you, there'd be a warrant for your arrest right now. You
Yes,
understand?
sir. They're great bondsmen.
You understand how important it is to take care of your business and make sure you know where you're supposed to be and when you're supposed to be there?
Yes, sir.
All right, so let's just chalk this up to a mistake and not let it happen again, okay?
Thank you.
All right, Mr. Klump is set for arraignment today. Mr. Gimbel, have you had an opportunity to review the indictment with him?
Yes, I have, Your Honor.
Okay, you may proceed.
His name is spelled correctly, and we just received the copy of discovery yesterday, and after speaking with the state, I believe they still have a video to provide to us. So we're lacking a video in discovery.
Okay. All right, then if his name is spelled correctly, and does he understand the nature of the charges brought against him?
Yes, he does, Your Honor.
All right, then the court, and he enters a plea of not guilty, correct?
Yes, he does, Your Honor.
All right, the court will accept Mr. Klump's plea of not guilty at this time. We'll enter that into the record. We will set pretrial in this matter for, you believe, January 7th would give you enough time to get your discovery and file any contested pretrial motions?
I think it will, Your Honor.
All right, we'll set Mr. Klump then for pretrial on January 7th at 9 a.m. And Mr. Klump, is Miss Burns there in the courtroom? Okay, and I have a note here that Mr. Klump needs to sign his conditions of pretrial release. So, Mr. Klump, after you receive that yellow copy that Mr. Gimbel's given you, then I want you to speak with Miss Burns, and she'll give you further directions regarding your conditions of pretrial release. What that means is that the court has conditioned your bail on certain terms, that you're going to report, that you're going to drug test, that you're going to not commit any new offenses. There's several things that you're going to have to comply with. Your violation of any of those may result in the court revoking your bail, putting you back in jail. Okay, so Ms. Burns will have more information and she'll give you that paperwork. If you have any questions, address that with Mr. Gimbel.
Yes, sir.
Right, those videos.
And Judge,
Okay.
Yeah,
Okay.
yes, Ms. Heisel.
I just heard Mr. Cox tell Mr. Gimbel, Ms. Abney let us know that those videos are available at our office for Mr. Gimbel.
Okay, good. Thank you.
That is all I have this afternoon, Judge.
Thank you, Mr. Gimbel. I appreciate you, sir. Mr. White, are you ready on Kelly Lambert?
Yes, sir.
All right, this is CR 19-200, State versus Kelly Longoria Lambert. And I believe we're set on the motion to revoke today, Mr. White.
That's correct, Your Honor. I was just hired on this case on Tuesday afternoon. Told not going to be ready to proceed today. Asked the court to reset it. I'm going to be here on the 15th, but if the court needs to put it on the 17th, that's fine.
Yes, Mr. White, if you don't mind, I'd like to put it on the 17th, just so we can abide by our COVID capacity guidelines. All right, court will set Ms. Lambert then for motion to revoke hearing on December 17th. And we'll do that at 9 a.m. That's our evidentiary day, and I believe we only had one set for evidentiary, so I'm going to go ahead and make use of that day.
Okay. Thank you, Your Honor.
You're welcome.
Thank you.
Your Honor, we just need a few minutes to bring our final defendant up, Mr. Wilson.
Is that Mr. Bill Stevens, the senior partner and founding partner of Stevens and Stevens Attorneys out of the great Gun Barrel City?
Yes, sir, it is.
Oh, wow, in the flesh. What an honor.
Absolutely.
How are you doing today?
I'm good, Judge. How about you?
Doing well, doing well. Okay, so y'all just need a few minutes to get him brought up?
Judge, he's really emotional. I asked him not to do him until the very end.
Okay,
And so I'm going to get him right. He'll be just a couple of minutes.
okay, all right.
He's back there crying. Oh. Don't leave up right now.
I don't think I'm hanging on to this. I don't come back to get emotional. There's almost never a time when I'm in court, I don't want to cry.
Yeah, really. I have the hardest time with that. Isn't something too old and stupid, you know? I'd probably stand with Brad for 5 minutes and he probably showed me. Right here, sir.
All right, hello, Mr. Wilson. How are you today, sir? Sir, can you just make sure you speak up? I know it may be a little bit difficult coming through there, but my court reporter's over here in the courtroom with me, and sometimes it's difficult to hear. So just make sure you speak up so she can write down what you're saying. Okay, sir?
Yes, sir.
All right, thank you. All right, Mr. Stevens, we are set today. My docket shows status in CR 18251, that is the evading arrest with a vehicle, and we're status for tampering or fabricating, and then for arraignment with bail jumping and failure to appear.
That is correct, Your Honor.
And do we have any additional information on what the purpose of the status was?
Judge, I was just appointed a week ago. I am unfamiliar with the prior cases, other than what my client and I have discussed. I am ready to go forward with the arraignment today. I've shown him the indictment and so forth, so ready to do that.
Judge, if the court recalls, Mr. Wilson was previously represented by Mr. Perkins, who filed a motion to withdraw, and the court granted that either last week or the week before. So I think it was set for status on appointment of attorney.
Oh, thank you. Thank you, Mr. Cox. That does. That refreshes my memory. Okay. All right. Well, let's do this, Mr. Stevens. Let's do as you suggest and conduct the arraignment, and then we'll set all the cases on a pre-trial and let you get up to speed.
Thank you, Your Honor.
All right.
If it may please the court, Your Honor, my client would advise the court that his name spelled correctly. He understands the nature and the consequences of the charges against him. We will waive reading of the indictment against him in the court. We will enter a plea of not guilty to the indictment and not true to the enhancement paragraphs.
All right. Thank you, Mr. Stevens. The court will enter Mr. Wilson's plea of not guilty and not true into the record, and we will set pre-trial and all three cause numbers on. Are you available on January 7th, Mr. Stevens?
In the afternoon, Your Honor?
Yes, sir.
Yes, sir. Yes, sir.
Okay, then court sets each case for pre-trial on that date.
All right. Judge, that concludes my business. Might be excused.
Yes, thank you, Mr. Stevens. Thank you, Mr. Wilson. We'll see you soon.
Thank you, Judge. Hang on just a second. I'll give you a copy of this, okay?
State, anything else that you're aware of? I don't see anything else on the docket.
No, Your Honor.
All right, thank y'all. Sorry for the delay. Once the Zoom locked up, I had to contact OCA, and luckily had a very helpful staff member there unlock me before the 30 minutes. So we'll, if that happens again, at least I have a phone number to try to shorten it. But
The direct number?
a direct number, yeah, direct number. So just goes to show you, it happens to the least of us.
Hey, Judge, can I say something to Hillary real quick?
Well, it depends. Is it going to be nice?
It'll be very nice, Judge, I promise.
Okay, yes. Then she says it's okay.
Hillary, you sent me something by email on a Lori Burge, B-U-R-G-E.